next invite Dr. Srilakshmi Peddada ji to speak. Dr. Srilakshmi Peddada has been an academician for over 25 years, and she's committed to philosophy of continuous learning. She has a deep interest in facilitating and doing research that is interdisciplinary in nature. She has a proven track record in providing quality education with a particular focus on jurisprudence. We apologize for the delay, Dr. Peddada, but please don't restrain yourself. Please go ahead and communicate everything that you had planned for our session. Thank you.
Thank you very much. Can you hear me? Yeah.
Yes.
Okay. Thank you very much, and thank you, INDICA and Paturaji and Meg Kalyan Sundar for giving me this chance. And it was worth the wait because each speaker has been most distinguished and scholarly in their presentation, and each presentation has been very distinct and different. So there was a lot of education in the whole process. So I would want to make a small amendment to my title, which I had given as Virtue, Ethics, and Lawmaking. The small amendment I would make to that is Virtue, Ethics in Administration of Justice, if you would permit me to make that change. Okay, so what I will do is I'll begin with talking about Dharma jurisprudence of governance briefly, and then I'll move on to administration of justice. Now, as I was listening, I was reminded of this statement or this verse of Mahābhārata, which says, there is no way of escaping from Mahābhārata. In one way or the other, you will have to come to it. So the famous statement, Dharme cha arthe cha kame cha mokshe cha Bhāratavarṣa, yada hasti tadanyatra yanne hastina tatvachit. So in matters of dharma, artha, kama, and moksha, whatever has been said here may be found elsewhere, but whatever is not found here does not exist anywhere else. All my life, I've heard my father saying it. I never paid attention to it. But now I realize absolute truth in what this statement says here. So moving on to my paper, I just think about the situation when the battle between the Pandavas and Kauravas is being fought. We see the noble Bhishma Pitamaha wounded and disabled, on the verge of breathing his last, still advising a distraught Yudhishthir on governance and administration of justice. All societies make rules and laws. However, the approach towards governance in the Dharma Shastra is elevated to a reverential sacred dharma, almost a purushartha, and not merely another political theory. So keeping this distinction in mind, we shall now begin with the familiar conversation between Yudhishthir and Bhishma on Dharma jurisprudence. And the discussion is on causality, whether human endeavor is the prime mover or destiny, that is Kala, that brings in the desirable change. Now, in order to influence the inquiring mind of Yudhishthir on the significance of human endeavor over chance or fate, that is the causal ground of every event that happens, Bhishma, what he does, he draws Yudhishthir's attention to a same issue that had happened some time ago in another place and another time. So he draws Yudhishthir's attention and narrates a story, and I take this story from Shanti Parva. In the city of Kapilya, there lived a bird by name Pujani in the palace of King Brahmadatta. Pujani was a rare bird who understood human languages, lived in the royal palace, and had been for many years a companion to the king. She would every morning fly to a distant place and bring from there 2 pieces of rare fruit, one for the king's little son and the other for hers. Both children grew strong on that magic fruit and played with each other. One day, while Pujani was away, the little prince, playing with the little bird, smashed him on the floor and killed him. On her return, seeing what had happened, Pujani, blinded with grief and anger, gouged the eyes of the prince by her deadly claws, saying, "What an ungrateful, cruel, untrustworthy wretch this princess turned out to be." She went to the king and told him what had happened and said, "She cannot live there any longer after what happened." Brahmadatta had in him a strong sense of justice and concluded that his little boy's cruel karma had invited instant punishment, which was just and right. He sought reconciliation with Pujani by invoking several arguments, one of which was that since Kala or time is the prime mover of everything, who could then be held responsible or guilty to whom? The king, being a just and a fair person, implores the bird to stay and not leave. He says, "I have forgiven you for what you did, and now you should forgive me for what I might have done. However, Pujani is not convinced. She says with great sadness, "Your son killed my son, and I clawed the eyes of your son and blinded him, and now you will kill me. So I must take care of myself, and so I must leave." Pujani gives several reasons for why she needs to leave. She says, "If everything is according to destiny and fate, as you say, why do we have emotions and expectations?" She asks the king, "Why do you physicians prescribe medicines for those who are ill? If time is burning all beings, then what good are medicines?" The conversation now focuses on the fearful question as to whether either of them could trust the other. Hereafter, after this episode, Pujani all along lived fearlessly in the palace, but now she fears for her life since she has no trust in the king. Friendship is now replaced by distrust. How can one repose trust in someone who has abused the power vested in him? In such a case, the protector becomes the predator. The important question then one has to ask is, what principles should guide relationships, any relationships for that matter? This is because relationships cannot be formed without trust. What then should a king do? The king therefore must endeavor to earn the trust of his people without depending on faith or destiny. Now Pujani therefore puts forward a strong plea, as Bhishma had done to Yudhishthir, exhorting the king to work towards dharma and for protection of his people above all. Pujani warns Brahmadatta about those who give up endeavor and says that those who give up endeavor end up inviting poverty and disaster. So before she leaves, Pujani offers some suggestions, making a list of virtuous principles that the king must cultivate. As a parting gift to the king, she offers some fundamental principles of dharma like vidya, shauryam cha dakshyam cha balam, dhairyam cha panchamam, mitrani shajanyuhu vartayanti tairbuddhaha. Knowledge, bravery, competence, strength, and patience. These are the 5 intrinsic principles of man based on which the wise do what they do. I've taken this from the Shantipal, chapter 139.85. Now, therefore, we see that the chief concern of dharmic political thought was power or bala. There were questions on the sources of bala or power, the purposes for which it is exercised, the purpose for which the power is exercised, and what were the limits of this power. Furthermore, the legitimacy to revolt against power when it is abused becomes adharma, creating conditions of great oppression and violence. So these concerns are contemporaneous and therefore relevant for us to dwell upon. Thankfully, the idea whether law is a divine command or is a product of the material conditions of the society was never problematic for Dharma jurisprudence as against the Western jurisprudence. We can see that the queries on power lead to an understanding of the purpose for which a king or the modern state exists. For instance, how does the state execute its powers, or the king uses sovereignty or sovereign authority? Thus, we see that the notion of good governance takes a central position in relation to using or exercising the power or bala. So I have a quote here from Shanti Parva which says, Sarve dharma raja dharma pradhanaha, sarve varnaha palyamana bhavanti, sarvastyago raja dharmeshu, rajyam syaga dharmachu puranam. Of all the foundations, the foundation of governance is central, for it is through it that all the human callings are cared for. Every human limit is inherent in the foundation of governance, and to observe limits is the deepest foundation of all. That is why Dhammam is considered to be an important virtue that a king has to practice. In other words, although the king is invested with the authority and power of governance, the true sovereignty belongs to Dharma and not to the king. This is a singular distinction about Dharma jurisprudence. The Dharma is above the king. Mahābhārata emphasizes this again and again in many places, in Shanti Parva and Anushasana Parva, particularly. By good governance, people prosper, and thus they in turn enrich the king, who protects them. This is the fundamental principle of governance in all areas of public policy. It is the duty of the king to always ensure that the subjects are free from fear, free from the fear of violence, which is the chief duty of the state. This is to see that the small fish are protected from the violence and abuse of big fish. So we see how the notion of fear is discussed threadbare in this particular context when they're discussing about governance. The Mahābhārata is conscious of how there is a possibility of state itself becoming the big fish, as we ourselves have witnessed in our lifetime. If that happens, there is oppression and terror, and adharma prevails. The alternative too is discussed here by Arjuna. He says, if there is no fear of rule or danda, then it is very likely that fear becomes the rule, and in such situations, the big fish do not let small fish survive. This leads to the powerful feeding on the weak, And the strongest advice to the king, and in a language that is impassionate, Bhishma again says, do not think that the weak are helpless. Take care that the eyes of the weak do not burn you and your relatives. There cannot be a greater social justice or sociology than these statements uttered by Bhishma, and to pay attention to the needs of the weak and not to ignore them as helpless and powerless. Bhishma thus gives a systematic exposition on the foundations of law based on danda of fear. Therefore, governance must be an essential principle of regulation, since regulations sets limits on the conduct of people towards each other. Now, the paradox here is that fear is the basis of governance, and the very purpose of governance is to secure freedom from fear for the people. So I may repeat this paradox again here. The paradox that is being discussed by Yudhishthira by Bhishma is that the foundation of good governance is fear. The wicked have to fear the law. And why do we fear the law? Because people can be secure and free from fear. So that is a paradox that Yudhishthira is being explained to by Bhishma. The fear that is discussed by Arjuna and Bhishma, in fact, is a fear that arises because of adharma. Bhishma now very convincingly places the onus on the king who wields the danda. This is because the king is more conscious than ever of the limitations of his power. Therefore, the king, more than anyone else, should endeavor to follow Dharma by creating conditions of good governance. After pointing out the role of fear as the restraining factor in human conditions of social peace and of human dignity, Mahābhārata returns to freedom from fear as the very condition for social peace. Whoever can give the gift of freedom from fear himself obtains great good, for there is no greater gift in the world than the gift of life. So in fact, what he defines is freedom from fear is a gift of life. That's what is equated to. Freedom from fear, or abhayadana, is therefore the very foundation of good governance. So we see how the concept of fear has been developed gradually, just fear from law to freedom from fear, which is now called as abhayadana, is perhaps the greatest foundation of good governance. Now, after exploring the concept of danda in governance, let us now examine the term raksha, or protection. Raksha connotes protection of the subjects from something undesirable or fearful. Law and governance in that sense are the instruments for that protection of the society and the people. This is the main fundamental function of the state. However, when you look at the wider meaning of Raksha, it is that the state should ensure not only freedom from fear, but more positively ensure that the people of the kingdom flourish, which is what Prabhava means as an attribute of Dharma. Trust, friendship, and caring are the elements of human bonding. Either it's the individual or even in social bonding. This is another important function of the state. So now the idea of Dharma thus becomes clear. It is not the paternalistic government that Mahābhārata is talking about. It says that each individual has to flourish according to his own svabhava. And it's not the government that is looking over as the father is looking over. So there is immense freedom that is being talked about here. In whatever way one chooses to define justice, law, and good governance, it must have as their basic attributes Prabhava, Dharana, and Ahimsa. Prabhava as an individual flourishing and succeeding, Dharana as maintaining, and Ahimsa free from violence. So Dharma is their natural foundation, whether between two individuals, family, or society at large. Now, if you look at Arthashastra in Book 1, it also says that the purpose of governance by the king or the state is to create social conditions, what we said, Prabhava, where every individual could follow his or her swadharma, his or her inner calling, and also achieve the orderly progress and welfare of the society as a whole, which is Lokayatra or Lokasangraha, which is the social welfare and creating social wealth as well. So it is what we say, Ubhau Satyadhikarasto Trayate Bhayat. It is by exercising the power of governance in accordance with Dharma, the people are made secure and free from fear. Mahābhārata says in clear and straightforward manner to the king, subject yourself to the discipline of Dharma, for it is in the discipline of Dharma that the discipline of your calling as the king lies. So Bhishma towards the end propounds 36 disciplines that a king should cultivate. And the main principle underlining them all is, interestingly, it is balance. Nothing ati, nothing too much or over, going overboard. It is maintaining a kind of balance. And the term balance is very beautifully elaborated in Arthashastra through an illustration. So as an executor and administrator of justice, the king should cultivate a keen sense of balance by which he can render natural justice to his subjects. Now, Arthashastra elaborates and it says, very beautiful an illustration or defining what is balance. Whoever imposes severe punishment becomes repulsive to the people, while he who awards mild punishment becomes contemptible. But whoever imposes punishment as deserved becomes respectable. For punishment, when awarded with due consideration, makes the people devoted to righteousness, whereas when punishment, when ill awarded under the influence of greed and anger, excites fury among people. I was myself taken by surprise when my daughter told me that the teacher was very strict with her, that she was her favorite teacher. So I think Arthashastra echoes that truth really here. Now, I move on to next part of it, administration of justice, which is one of the most important obligatory functions of the kings. The Shastras mention different courts taking up disputes to be adjudicated at different levels. The hierarchy of courts has been mentioned in Brihaspati Smriti in particular. And let me just give you a list of these courts. Most of these are very familiar to us. Kula, the lowest one. This is the hierarchy of courts that I'm reading up, the lower to the higher court. Kula, the family councils. Shreni, a corporation. Gana, an assembly. Adhikrita, court appointed by the king. And Ripa, where the king himself sits in that particular court. Apart from this, they have, according to Brihaspati Smriti, Pratishta, a court established in a village or town. And they have mobile courts too in those days, which were called Apratishta, a mobile court moving from village to village. Mudrita is a court appointed by the king and authorized to use the royal seal. Shashita is the court where the king himself presided. And I have taken this from the Gharpure work. It is by Narada Smriti and Brihaspati Smriti that we know about the presence and function of the court and their hierarchy. The other details with reference to court's jurisdiction and power are such that the right to appeal has existed in almost all the courts, where a party could appeal to the king to review the decision given by any tribunal. Now, so after the courts, we go back automatically to those who oversee the court work, which is the judges. So we have to see, have they talked about judicial virtues? Are there something called judicial virtues? And how should be the judges appointed, and what are the virtues of the judges that are considered? There has been a criteria that has been set, and also that there were qualities that have been listed or recommended in order to appoint them, anybody as a judge. Now, the qualities that a judge must possess are in fact asserted in almost all the Dharma Shastras. According to them, the judge to be appointed was called a prang-vivaka. A judge should be such that he should be capable of asking questions, prang-vivaka, and able to discern with vivek, discern right from wrong. It was directed further that he must be possessed of self-control, belong to a respectable family, be impartial, intemperate, firm, fearful of future, virtuous, attentive, and free from passion. Now, let's look at the qualification criteria. Now, the judge to be appointed must be well versed in vyavahara, that is the judicial procedures. And he should know all the dharmas, that is all laws on all topics. And he should be bahushruta, great scholar. And pramanagya, he should know thoroughly the law of evidence. And nyaya shastra valambina, meaning a judge himself should be a law-abiding person. And he should be one who has studied Veda, Tarka, logic, and he should have knowledge of Mimamsa in order to interpret the law. Judges, therefore, should be impartial, independent, and fearless. The king, in fact, is not to be angry or interfere with judges for giving a frank opinion. The noble role of judges in the administration of justice is well laid out in Smritis. This is in a way demonstrates the independence of judiciary and the supremacy of dharma as binding even on the king. Now, the king himself was required to preside over the highest court, and the court must be set in the capital. And so the king is required to preside the highest court and dispense justice according to law, for which he is assisted by the judges. And interestingly, they make a very amazing point about how a king must present himself in the court. A king, while investigating cases, should enter the court of justice without ostentation in his dress and ornaments. He shouldn't be wearing ostentatious dress and ornaments, preserving a dignified demeanor accompanied by his counselors. So perhaps we should also suggest this to the courts currently to change their robes. When the king himself looks into the causes according to Dharma, people are happy. So Dharma Shastras always exhort the king to be present in his court. In the case of disputes about trades and craftsmen, assistance of experts is taken to arrive at a correct decision. Now, generally, the Shastras suggest that unanimous decisions should be recommended, failing which what happens is doubts are created in the petitioner and the defendant, and therefore a unanimous decision is far more satisfactory, unlike a divided opinion. Now, there is another point that is interesting and which reflects the modern legal profession also. They do talk about the amicus curiae, that you must take assistance of learned scholars, and they also impose the learned scholars a duty to participate. This is an interesting approach to interpret law correctly. A scholar who is well versed in law must come forward willingly to restrain an unlawful law or a patent injustice being perpetuated by those ignorant of law or even when intentionally done. Now, this is because law is the voice of the deity, and therefore an ordinary citizen who is scholarly and well versed has the responsibility and the duty to participate in the legal proceedings to stop any unfair decisions or unlawful decisions being made. Now, as I have just given you the court procedures and the hierarchy of courts, we could also take few cases and see how cases and disputes have been adjudicated and how beautifully they had followed the rule of law as set in the Shastras. So here are some interesting cases that I would like to list out. The first one I take is from Raj Tarangini, which is recorded in 930 CE. This is during the period of the Raja Yashashkara of Kashmir. And he was asked to decide on an appeal. So what he did, he decided on an appeal and reversed a decision regarding the ownership of a well in a property. Now the matter goes like this, the issue. Yashashkara, I'm sure as a king, had excellent understanding of evidence law, because what he did was he did a careful scrutiny of the evidence in the case, and he came to the conclusion when he read the sale deed, the word kupa rahita, that is without a well, was made to be read as kupa sahita, including well, by the scribe who had been bribed by the Vendi. The Vendi had bribed the scribe, so he had carefully overwritten, and in place of rahita, he wrote sahita. Having scrutinized the sale deed, he discovered the fraud, decreed in favor of the plaintiff appellant. Looking at the fraud and the dispute following it, I'm sure that the legal profession must have been thriving right from those period onwards. Now, here is another interesting case which has been recorded in Raj Tarangini. Now, in this case, it needs the presence of mind of the king to really come to a decision to resolve this dispute, and also at the same time be well learned about the law itself. The petitioner was a poor man And he had appeared in the court, but it was quite late in the evening. The king was about to rise from the court after a whole day's session. When it was informed that a poor man was waiting, he was willing to listen to his case. So the poor man, the petitioner, submitted like this. He said, I had with much effort earned 100 gold coins. While traveling, I stopped at Lavanotsa that evening. And next day, when I was about to leave, my purse accidentally fell into a well covered with creepers. And I could not locate my purse, and I was lamenting for a long time. Thereafter, an energetic young man came and asked me what I would give him if he took out the purse from the well. Helpless as I was, I said, You may take out the purse and give me whatever you like. He promptly brought out the purse from the well and gave me 2 coins and took 98 coins for himself. So he tells the king, this is nothing but fraud, a misuse of my polite expression in distress. Now, the next day, the petitioner identified the defendant who had been summoned by the king. The man fully agreed with facts stated by the petitioner, but maintained that the retention of 98 coins for himself and 2 to the petitioner was based on the petitioner's own agreement. Now, the king, after examination, decreed that the 98 coins will go to the petitioner and the balance 2 coins to the defendant. Now, how did he come to this conclusion? What was the rationale or the ratio? Now, the king remarked like this. He said with great clarity and compassion that dharma, justice, has no other task except removing adharma, and the two tread very closely. The fairness of the decision here is apparent, but you need to give a rationale, a reason behind this decision. And it is pertinent to note here that the decision is perfect in accordance with the law on gifts. Now, in fact, the commentary by Asahaya on Narada Smriti of law on gifts says something close to the effect that what was promised foolishly or by one in distress is invalid. So the significance, the reason why I have given these illustrations is to demonstrate how deeply legal institutions were functional and functioning on the principles of Dharma Shastras. Now, I have one more interesting case which establishes beyond a doubt how deeply the principle of Dharma and the independence of judiciary has been much before India got its independence. It is even more telling to recall the supremacy of Dharma that prevailed in a way where the judiciary itself was put to test. This is an illustration from Maharashtra in 1774. And I've taken it from the History of Maharashtra by Sardesai in the volume 2. This is a case which is much known in Maharashtra, a case decided by Rama Shastri, who was the Chief Justice to the Peshwas in Maharashtra. After the death of Peshwa Madhav Rao in 1772, his only surviving younger brother, Narayan Rao, aged 17 years, succeeded to a position of Peshwa. His uncle Raghunath Rao, being ambitious for power, hatched a conspiracy to overthrow Narayan Rao. As a result, Narayan Rao was murdered and Raghunath Rao assumed power. Ramashastri, the Chief Justice, probed into the murder of Narayan Rao, and he accused Raghunath Rao, who was the current Peshwa, and 49 others, including a woman, guilty of murder, and convicted him. And the decision was communicated to Peshwa Raghunath Rao according to the Rajdharma, where the Rajdharma says that the quantum of penalty is vested in the king, and here in this case the Peshwa. Now the Peshwa took no action as he himself was guilty of murder. Now what is most admirable here is the Chief Justice fearlessly, the Chief Justice Ramashastri fearlessly insisted on his decision being given effect to. Now, as one can imagine, as a consequence, the Chief Justice was dismissed by Peshwa from his post, and the Chief Justice quietly retired to his village. But you see what is interesting here? That Dharma asserted its supremacy through the people. They refused to recognize Raghunatha Rao as Peshwa, as he was found guilty of murder of Narayan Rao, who was the lawful Peshwa. In place of Raghunatha Rao, a council of 12 persons called Bharabhai was formed, which took over the administration after deposing Raghunatha Rao. This case, I feel, is an ever-inspiring one, a glowing tribute to the supremacy of Dharma, the independence of judiciary, and the exemplary conduct exhibited by a judge. But now we have a modern constitution, the rule of law, equality before law, and the application of principle of natural justice are the settled principles of law of this land. Though the constitutional law is borrowed from the common law countries, the lived experiences are an admixture of customary and traditional practices. So the continuity of ancient principles in social practices can neither be fully confirmed as a major influence in law, nor can the cultural underpinnings be denied. So this rather discomfort fit in the legal position necessitates, I feel, a deeper understanding of Hindu jurisprudence. This will provide a conceptual clarity in the development of modern law and its interpretation. In fact, a fresh repositioning of the legal authority would mean to repose confidence in the capacious quality of ancient Dharma legal systems, to adapt, mingle, and blend with the modern legal system. Though the modern constitution is juxtaposed on ancient dharmic laws, I see, in fact, the strength of the foundation of Dharma is holding up beautifully for democracy to thrive in this land. So that's my presentation. Thank you, everybody, for giving me this chance here. Thank you. I hope it was.
Thank you so
I
much.
haven't been too long. You were polite and not reminded me if I overshot by any chance.
Thank you so much, Dr. Peddada, for all the insights and for staying on and sharing all that you wanted to as part of this symposium. I'm sure it enriched everybody who stayed back to listen to your perspectives and you gave it across a fairly good time sweep.